So welcome to another edition of the Global Antitrust Institute's discussion series. The discussion series is a series of conversations we have with antitrust experts and economists about hot topics, recent developments, practitioner tips that we think would be interesting for our viewers. My name is Rybnicek. I'm a antitrust attorney at the law firm Freshfields Brookhouse Deringer here in Washington, D.C. I'm also a senior fellow at the Global Antitrust Institute and adjunct professor at the Scalia Law School at George Mason University. We've done several of these now. You can go online and view some of the other editions. Josh Wright talks to FTC Commissioner Noah Phillips. Judge Ginsburg talks to former FTC Chairman Bill Kovacic. There are many others. Today, we have the privilege of being joined by Dr. Joanna Tsai, who is an antitrust economist. She's vice president at Charles River Associates, where she's in the Antitrust and Competition Economics Group, and has worked on a lot of high-profile matters, including Evonik PeroxyChem, a recent case in front of the FTC, Lindy-Praxair, the Lindy-Praxair merger, and is generally writes a lot in the area of antitrust, in particular on intellectual property, issues related to the China regime, and many other issues. So good to be with you, Joanna.
Good to be here, Jan. Thank you for that introduction, and thank you for having me here.
Yeah, no, this is exciting. I am going to brag that I've now had two economists on this discussion series, Hal Singer before, and now you. And
two for two?
Yeah, 2 for 2.
That's impressive.
So hopefully I'll learn something both times, and we'll have a good conversation. So we're going to talk about a whole bunch of things. It's kind of going to be an antitrust potpourri of topics. I think there's some interesting things to talk about just kind of generally about antitrust or economics in antitrust. That's certainly been part of the recent conversation. We can talk about our case, Evonik PeroxyChem, which we both worked on and coordinated effects at the agencies. And then I do want to talk about kind of your experience with the China merger regime and just anti-monopoly law generally. Any reflections you've had on that, because there have been a lot of changes and developments over the last 10 plus years since that law came into effect. So with that, maybe we can just jump right in. There's obviously antitrust is having a bit of a moment, which is exciting for a lot of people, especially those that are in antitrust, because it has become a kitchen table conversation piece, and a lot of people can relate to it or want to understand it better. And lots of people have views and ideas about it. And, there's obviously this narrative where certain people think that there's been a lot of increasing concentration and increasing market power in the economy, and that may be or is caused by lax antitrust enforcement. I want to put kind of that evidence aside, because I think a lot of people have different views on the quality of that evidence and how to interpret that evidence. But one of the solutions that has been proposed is kind of taking some of the economics out of antitrust almost, and returning to maybe a more simplistic way of doing antitrust. There's criticisms that antitrust or that economics makes antitrust more complicated, technocratic and wonky, and kind of only accessible to a few. Some might describe it as witchcraft. And that it doesn't improve transparency and enforcement. And so one solution would be kind of to go back to, one idea is to go back to the 1968 horizontal merger guidelines, right? Which are pretty simplistic in the sense that they will focus on market shares, and even a kind of a small trivial incremental increase in share would be enough to say a merger is anti-competitive. So having you here as an economist and as an expert in antitrust, and having worked both within the agency and then obviously outside in private practice as well, and academia as well, wanted to kind of get your perspective on why the incorporation of economics into antitrust has been, if you agree, a positive for antitrust, and why, and any other views you want to share about, the role of economics in antitrust today.
Sure. Well, first of all, let me just say that, I'll admit, antitrust economics is a fairly specialized field. It is, a lot of us economists working in this field have PhDs. A lot of us specialize in particular in industrial organization economics, which studies, sort of how firms price and how firms react to competition with others. So it is specialized, and the economic tools that we develop and use, it is more complicated than, just calculating market shares. That said, I think another question you've raised here, with what we've heard in terms of criticisms is it necessary for it to be that complex, right? Are we getting something more by employing a more complex analysis? Are we, doing a better job, at, merger enforcement by employing these more complex analysis? So in a sense, is the complexity justified? So there, I think I want to sort of go back to the basics a little bit in terms of what merger analysis is about. I mean, you mentioned, the guidelines in the 60s where, let's calculate market share. How are we going to calculate the market share? What defines that market? I think in of it itself, in that basic step, is going to require some kind of analysis, thinking, that's, even if we don't call it economics, some kind of thinking about, what should be included in the denominator of your share calculations? Should it include, everybody in the industry, everybody in the world, everybody in, in the United States, right? I mean, that would have significant implications on whether you calculate a small share or a bigger share, or, and which is the right way of looking at size and competition, right, where the merger is taking place. So I, just want to say, even market share calculations will involve some sort of analysis to, put it in the right context. It's important to keep in mind that with mergers, there is a potential harm that could result from mergers, and there could also be potential benefits, right, coming from efficiencies. And economics helps to discern. In my view, economics helps to discern pro versus anti-competitive mergers. And so we talked about, on the one hand, there's a potential for harm to consumers. On the other hand, there's potential for benefit to consumers. And the two are going in different directions. And this is also where, it's important to, quantify, right? When you have two forces going in opposite directions, which is bigger? And that, in order to know which is bigger, that involves some kind of quantification. At a sort of even more simpler level, economic analysis can, as I said before, can help to identify the relevant competitors, right? And evaluate the closeness of competition. There are mergers that, are unlikely to substantially lessen competition because they involve distant competitors where the merging parties each compete closely with other competitors.
Right. I think that's obviously absolutely right. And, it's also, it's not entirely clear that economics has to be, as you say, I mean, there are levels of complexity in the economics that you employ in antitrust. And certainly in cases that, if you think about a merger case that goes through in the US, a second request, kind of a full-on investigation, there's going to be a lot of opportunity to do data analysis and to run models and do all sorts of things. But, there are also kind of in the initial 30 days, right, after you make a merger filing, where it's, frankly, it's not possible because of time constraints to get all the data, to do all the analysis in time to kind of present it to the agencies and to explain it.
Yeah.
So there, I mean, and I know that you've written a paper on exactly that, on what you can do during those first 30 days. And those things are going to inherently kind of be simpler, and not necessarily kind of the witchcraft economics, if I can use that phrase to have a little fun. Can you talk a little bit about the breadth of what is available in terms of economic analysis? And some of it, I think, will maybe not surprise people, but will come across as, oh, well, that's, I wouldn't have thought of that as economics, but it's obviously very important to understanding competitive effects.
Mm-hmm. Sure. Well, you're definitely right. There are gradations of complexity in economic analysis, and a lot of, and which is, one motivation I had in writing this paper, clearing the deal in the first 30 days. And of course, the paper describes, I think, various types of analyses, with varying levels of complexity, and in reality, it's true. The first 30 days go by so fast, and even if the economy starts working prior to those first 30 days, it is more likely than not, in fact, I would say for most cases, the economic analysis that you would present to the agencies in that period of time, if you do present economic analysis to the agencies, are more straightforward analysis focused on unilateral effects. So for example, every case is a little different, and what's relevant to that particular case is different. But if you have, say, good bidding win-loss data, that might be a good analysis to show, for example, issues such as closeness of competition, whether your merging parties are often, the only two competitors, bidding for a particular customer, let's say. If you could use bidding or win-loss data to show diversions, between the merging parties versus other competitors, that would be very informative too. And those are the types of analysis that should be, given, reasonable state of the data, that should be doable, for the first 30 days. Moving on from, say, win-loss bidding type of analysis, I think, there are, econometric studies that, for example, can look at, what happens to prices, when you have different sets and different numbers of competitors competing in, say, a given geographic area versus others. And those types of analysis could be used to then predict what would be the effect on prices as a result of the merger. And, there are a lot of different types of analysis, but I would say, it is not the case that we pursue every single type of analysis, for every merger. It's important to prioritize because of, budget reasons, because there's constraints on time. And, in identifying the priority analysis, I would say it's important to do a combination of, making sure we communicate with the agencies to determine to be, on the same wavelength in terms of issues and concerns. And then also part of it is also based on past experiences in other similar types of cases, what would be most informative, to the analysis and to the agencies as well.
Right. And, just in case some listeners aren't familiar, we talk about the first 30 days because, at least in the US, that's the period of time that the agencies have to decide whether or not to issue a second request and to extend the investigation into something that is much more burdensome and in depth and detail and lasts for several more months. But I think, even those types of things kind of help to understand the things you mentioned in terms of economic analysis, helps us understand the closeness of competition between, for example, merging parties, or the effects of a particular type of conduct, and tell us a lot more than just a share calculation might. Now, and I don't want to suggest that there's no room for presumptions, or there's no room for safe harbors either, right? I mean, they're, you know, developing antitrust law through the use of economics also kind of deals with administrability, right? And where we know through the empirical evidence that a certain type of conduct is more likely than not to be anti-competitive, then, you know, we can make shortcuts. But you know, and we see that in cartel cases, right? And you see that in other instances. And so that's not to say that, you know, the conversation can include discussion of presumptions.
Yeah, well, in fact, I think given agencies, do typically start by looking at combined share and concentration. This is our U.S. agencies, as well as, we will talk maybe a little more about this later in China. If they are, say, in a particular merger, if they're high, but you believe that the share or the concentration are not quite representative to the actual competition at work, and in particular between the merging parties, then that's what I would focus on. What would be the analysis that can help to show that, right?
Mm-hmm.
In order to, move the agencies away from, from what they are inferring based on presumptions.
Right. Okay. Well, I do want to move on to talk a little bit about our case. I don't know if there are is there anything else that you want to add before we move off kind of the general topic of economics, or any lessons for lawyers or businesses that you have worked with in terms of lessons you've learned about things that lawyers and clients can do better?
Well, I'll never say that lawyers and clients can do better, but I think I will say, I will give my recommendation as to, how to work together with an economist so that the economic analysis is as effective as, as they can be. My suggestion there is, I think, you're interested to hear, your experience on this, of course, but, when possible, I think it's important to incorporate your economists in, broader case discussions and interviews with business executives and some facts and key documents. It is much less effective for the economist to work in a silo for the following reason. It really helps to build the right framework and to develop consistent economic evidence, with other evidence that lawyers may be seeing. And of course, if the economic analysis, results in conclusions that are inconsistent with other types of evidence, like qualitative documentary evidence, and you got to figure out why. Right. And this is something that, time and time again, I find that, it's important in front of the presentations to the agencies, the lawyers and economists at the FTC and DOJ have many, many years of experience in this, and they are quick to pick up any inconsistencies that may exist. And, that would just tend to raise questions rather than being persuasive. And there are facts that, with regard to how competition works and the characteristics of the merging parties versus other competitors, for example, that could, have implications on how competition is modeled, by the economist.
Yeah. No, I think that's right. And I think, I certainly strive to get the economists incorporated as early as possible, because it's a different set of insights and analyses and understanding of the deal or the conduct. So, and I think being synced up early on is important. I mean, just as important as, making sure that your economist or the lawyers or whoever knows the facts of the case and isn't kind of thinking in the abstract almost. But I agree, you have to get synced up early.
Yeah. And and we've seen this too in litigation, the judge, would look to whether, an economist's model and the work and the analysis is, is tied to and incorporates the realities of the industry. And that's something that, something that's intuitive, that incorporates the reality of the industry is something that I think would make, your economist's analysis a lot more persuasive and effective.
Yeah, absolutely. So turning to litigation, we both worked on the Evonik PeroxyChem matter, Evonik's acquisition of PeroxyChem. And so we'll talk a little bit about that. Let me just give a little bit of setup for the audience on the deal. So Evonik announced this deal back in November of 2018. It was notified to the FTC. It went through a second request, a lengthy investigation. And in, I think it was August of 2019, the FTC issued a complaint suing the parties to challenge the transaction. And the complaint included both unilateral effects and coordinated effects complaints against the transaction. Though I think, you and I think we both agree that the coordinated effects were maybe the stronger motivation in terms of challenging the transaction. They certainly were not just an ancillary part of the complaint. They motivated it pretty heavily. And then for the next 3 or 4 months, we did discovery and went into litigation in November of 2019. And then earlier this year, at the end of January 2020, Judge Timothy Kelly, issued his ruling and denying the FTC's request for a preliminary injunction to block the transaction, which was pretty satisfying for us, and it was a pretty rare victory. Despite all the talk about antitrust being lax and the agencies not being able to enforce the current laws. The agencies, both the DOJ and the FTC, have a pretty remarkable track record winning merger litigations, and this is only the FTC's second loss since 2015 and third loss since I think it was 2010. So they lose pretty infrequently, and they lost in this matter. And part of the case that they couldn't prove and substantiate to the judge's satisfaction was this kind of coordinated effects theory. And the product at issue in Evonik PeroxyChem was hydrogen peroxide, which everybody knows from the little brown bottles at the CVS and Walgreens. But it's used for many other things, as you and I both learned over the last year and a half. Rocket propulsion and aseptic packaging and bleaching pulp and paper and things like that. So there's obviously, but as you can imagine with hydrogen peroxide, there's certainly at least a claim that it's a homogeneous product, and there might be other features of the market that are vulnerable to coordination. I want to talk a little bit about kind of what you've seen in terms of the agency's approaches to unilateral effects versus coordinated effects, and how you kind of interpret what you see coming out of the agencies on that score, and why we might be all a little bit more familiar with unilateral effects cases than coordinated effects cases.
Sure. By the way, and first of all, that was an excellent summary of about a year and 4 months of our lives.
That's right.
I was having flashbacks as you were describing that period of time when we were, starting with, I think, the first phase, the first 30 days, walking into the rest of that journey. But yeah, so with it is the case that we see, and I've seen this both in my consulting practice as well as when I was at the FTC, the economist toolkit is much more developed, and I would say more advanced on unilateral effects than coordinated effects. Why that's the case? I think I have a couple of hypotheses. I think one, unilateral effects are more common I mean, in almost all merger cases above a certain threshold, unilateral effects is always evaluated. I think that unilateral effect models are also simpler, easier to simplify. I think, there are, of course, there are merger simulation models that looks at unilateral effects, but, I think, in the last, 10, 20 years, we've been able to simplify that into, the sort of tools that we see in the horizontal merger guidelines in 2010, for example, that is aimed at, a more simplified way of looking at unilateral effects from, the sort of more theoretical, extensive models. I also do think that there are comparably more certainty in unilateral effects. And I know, some people might laugh at that because, economists always talks about, well, it depends, and there are caveats and there are assumptions, of course, and, and the results could, depend on some of these things and whether you're making this assumption or that. I would like to say that, yes, I mean, I think with models, I mean, we are doing predictions in essence, right? And that requires some assumptions because we don't completely capture, the real world, in a model. But, comparably speaking, between unilateral effects and coordinated effects, in unilateral effects, you're not trying to, also anticipate the reaction of each of the other competitors that could, potentially lead to a wide range of behavior. So, I think comparably, there is some more certainty in unilateral effects in terms of the conclusions and the range of conclusions that you can arrive at with unilateral effects. That said, there have been a few attempts to develop practical tools to measure the magnitude of coordinated effects. The state of economic analysis in this area, I think, is still limited, and there is no consensus yet on how this issue should be approached from a quantitative perspective. I mean, there's certainly been attempts, but I don't think we're quite there yet, and it should be interesting, especially given the more recent interest from the agencies that we have seen in coordinated effects theory, whether this is something that would be on the table for development, before we get to the next, new horizontal merger guidelines.
Right. I mean, in our experience, kind of in front of the agency, I mean, if you look at the guidelines, there's kind of three factors to whether or not the agency is going to bring or is likely to bring a coordinated effects challenge. One is, does the merger kind of increase concentration significantly and make it a moderately or highly concentrated industry? Is the industry vulnerable to coordination? And three, does this particular merger somehow increase that vulnerability? And most of the action in the coordinated effects discussion is in that second bucket of, is this industry vulnerable to coordination? And those are kind of all qualitative characteristics. Is the product homogeneous? Is there price transparency? Is there production transparency? There's elasticity, so there's some economics there. But a lot of the stuff is qualitative, and you kind of discern it a lot from documents and other things. That makes it the economist. I think the economist role probably in that is less certainly than the unilateral effects modeling, but that doesn't mean that you didn't have a lot of work to do, because to prove up those kind of qualitative aspects, there's a lot that you did, which was kind of not predictive. It was historical, looking at kind of what had happened in the industry over time.
Yeah, I would say these are the factors are stylized facts, right? But it does, some of them did involve some kind of quantitative or economic analysis to establish, whether, hey, let's look at the product characteristics. Let's also look at their pricing, by end uses, for example. Is this a homogeneous, product? So there are analysis that was certainly undertaken to try to show that, or for example, what were the, but there you're definitely right. It is of a different level in terms of, in terms of, say, an econometric analysis, to estimate values to then use to predict what might happen. You, in the in these situations when we're looking at vulnerability, I think one aspect of it that is striking is that, we may say, oh, well, this is, there are, there heterogeneity to the products, or, there are, asymmetries in the firms, in the cost and in the productive capacities. But there isn't really, a sort of metric to say, all right, well, it might be a continuous function, right? I mean, products are, you could say this product is more homogeneous than this other product. At which point, does this turn over to the difference between, this means this is vulnerable versus not vulnerable. Same thing with asymmetry. I mean, I think asymmetry is almost a little easier in the sense is that you're comparing, whether the merger would, might create, more equal sized firms, or, more asymmetrically sized firms. And so that seems more clear, but in terms of other factors, I think it's, it's qualitative in the sense that, you're describing what the characteristic is, but there's no metric to distinguish, what would make it, more or likely, or whether it should be a check or not a check, right? In terms of vulnerability factor.
Yeah, I mean, the asymmetry point's interesting because it relates to that third factor that does this, we talked about the three prongs: one, increasing concentration; two, vulnerability, an industry vulnerable; and then three, does this merger make it more vulnerable? That third has been some topic of debate. Back when we both worked for Commissioner Wright, there was, he dissented in this Fidelity National matter in which the point of contention between the majority, which obviously prevailed in its view, and Commissioner Wright was that the mere reduction in the number of firms wasn't enough to tell you that the industry would be more vulnerable. And this is an issue that came up again in the Evonik PeroxyChem matter, and the Judge Kelly, actually noted this in his decision, that you can't just have a reduction in the number of firms. You have to have something else. And that something else could be you're eliminating a maverick, or, as you say, increasing asymmetry. Maybe if you could just say, it's not necessarily intuitive, right? Most people will think, oh, well, you reduce the number of firms and it's going to be easier to coordinate. It's going to be easier to have a common understanding, even tacitly, right? Why does increasing asymmetry potentially make it harder to coordinate?
Yeah, so this is an insight from economics, but asymmetry, let's say, I think I referenced, asymmetry in cost or asymmetry in productive capacities, but let's just take productive capacities as an example. The intuition is that the larger firm in terms of productive capacities is more tempted to cheat on the collusive conduct because it has more capacities that it needs to fill. So it can gain more in the short term by selling those extra capacity. And then at the same time, it also has less to fear in terms of retaliations afterwards, because by definition, the smaller firms would not have a lot of productive capacity to be able to, use that capacity to punish the larger firm.
Right. Yeah, and I think in the FTC sued to challenge another merger right before the Evonik merger, maybe a year before, I guess. It was the Tronix Cristal transaction, and there the FTC prevailed, and there they also alleged that the merger would create two big firms, both around 30% share. So feeding right into that point and kind of substantiating that third prong, I think, a little bit more than they did in our case.
Yeah, absolutely.
Okay. So I think we could talk about Evonik for hours if we wanted to.
We
might lose listeners, but I'm conscious that you also have a hard stop and we've got limited time. So I want to move on to talk about your experience with the China regime. You're not just a US expert, you've done actually a lot of work in China and also in Brazil, which is fantastic. If we could just talk a little bit about China, because I think that is a regime that is a merger regime or an antitrust regime that is interesting to a lot of people, if for no other reason than it's a big global economy. China's had its antitrust laws since 2008 and has had some reforms over the years. And I think people think that there have been some growing pains, but that, for example, the merger review timeline has substantially decreased since the beginning. The conversation about antitrust is not just happening in the US. That's the one I think we're most attuned to because it's where we see the debate. But there's reflections on antitrust happening in Europe and in China. Europe, we just had this court decision in the CK Hutchison Telefonica merger appeal, which Freshfields was involved in, my colleagues in Brussels and London, where they won on the appeal, and the decision from the court really articulated that the European Commission needed to better substantiate its evidence and really showed a understanding of economics and the importance of economics to antitrust, which is kind of interesting to read in the context of what's happening in the US right now in the debate and some of the pushback on how antitrust has developed. I mean, one of the things that was discussed in the European decision is that harm to competitors isn't enough, and that has to be harm to competition. That is a principle that has been long fundamental in the US, but to see it kind of in the European decision is interesting. And similarly, there have been developments in China, so would love to hear kind of your views on and experiences with the regulators in China.
Sure. Even though most of my practice is here in the US, I've had some opportunities, the pleasure to work in front of SAMR, MOFCOM previously, now SAMR, in the last few years. In this particular example, I was retained because the Chinese Competition Authority, MOFCOM at the time, had asked the parties to have an economist submit a report and opine on essentially relevant geographic markets. So this is a case where this is a merger where there are a lot of products, and some of the products, the competition might be regional. MOFCOM was interested in seeing an application of an implementation of the hypothetical monopolist test, including the SNP. And that was the context in which I was retained to provide this analysis and the report to MOFCOM. What was very interesting there is, because of the number of different products, there are, certainly data challenges as always, but, at the end of the day, because this is a product where it's shipped to customers and transportation costs are pretty significant. This is reminding me of hydrogen peroxide, but in this other case, it's also the case. And we looked at, essentially geographic areas surrounding the customers. In our guidelines, for example, there are sections under geographic markets where you look at, there's a question as to, whether you're supposed to be drawing circles around the supplier plants or around customers. Ultimately, in situations where, products are delivered to customers, you draw them around customers because what is relevant there is to the eyes of that customer, which suppliers, from which plants can profitably and competitively ship to that customer. And then of course that, determination then allows us to look at, the landscape of competition, within that area to say, do the merging parties compete there? Was it just one of them that competed there? and whether, whether there were other competitors and who were those competitors. And so, so the analysis went through, I think, I would say a fairly comprehensive analysis, essentially product by product and regional, markets by regional markets. And we even also proposed, I think there were two two ways to draw the circles around the customers. One was, whether it was, whether there have been suppliers that supply the customers, and whether there were the suppliers that haven't supplied those customers, but may be relevant in terms of competition in the area, because they would technically be able to, or be profitable, can profitably ship to those customers. And if that's the case, we would want to consider them. In doing some research for a working paper that I'm working on, I learned that I didn't know this before, I don't know why, but in reading MOFCOM's decision for this case, I noticed that MOFCOM actually adopted that methodology that I proposed in the report. And at least that's the way I view it. Maybe MOFCOM would have reached the exact same conclusion anyway, but that's my story. I'm sticking to it, and
That's right.
And it was very satisfying and rewarding, for me to see sort of economic analysis at work, and being able to assist, with providing, the proper context in evaluating competition in those markets.
Right. So it sounds like a takeaway is obviously that, maybe, I don't know if it's surprising, but certainly interesting that, your experience with MOFCOM or SAMR now is that they were interested in the economics and in kind of understanding it, and quite frankly, were, even incorporating it into their analysis publicly.
Yeah.
So, I think for those of us who think that antitrust or that economics is important for antitrust and helps us kind of reach better outcomes, that is a heartening anecdote.
Definitely. I think that MOFCOM and SAMR today is definitely very interested in the economics, and even in more recent decisions from MOFCOM from SAMR that I've seen, it suggests, quite a bit of underlying economic analysis in their decision making.
Good. Well, you've been generous with your time. I know you have to run to some other things, but I also know that you're working on lots of papers and interesting research. And so maybe you can come back on sometime later and we can talk about whatever it is that you're working on now once you flesh it out, and we can do this again.
I would love to. It's been a pleasure. Thank you, Jan.
Thanks, Joanna.